If you ask most older homeowners what the safest asset in their life is, many of them will give you the same answer without hesitation: the house. Not the checking account, not the brokerage account, not the IRA. The house, it is the thing they can see, the thing they paid on, the thing they raised children in, the thing that survived layoffs, recessions, inflation, family chaos, and decades of ordinary life. The house feels like the untouchable part. That is exactly why the 5-year rule is so dangerous, not because it is hidden in some technical manual no one could ever find, because it collides directly with one of the most emotionally important assumptions older Americans carry. They assume the home is the one thing that will remain standing for the spouse, the children, or the grandchildren. No matter how bad a medical crisis becomes, that assumption is often only partially true. And partial truth is one of the most expensive things in finance. It gives people just enough comfort to stop asking the next question. The next question is always the one that matters. Not, is the house generally exempt while I am alive? That is the question most people ask. The better question is this: what happens to the house if I need long-term care, I run out of money, I apply for Medicaid too late, and the state later comes looking for recovery? That is the adult version. The adult version is uncomfortable. But discomfort has never bothered me very much in financial life. Comfort is what ruins people. Comfort is what makes them postpone planning until the calendar closes around them. Comfort is what turns a home from a family asset into a trapped asset. Comfort is what makes ordinary gifts to children or grandchildren feel harmless when they may later become evidence in a penalty calculation. That is why I want to begin with the hardest truth. The real danger here is not simply that Medicaid has a 5-year look back. The real danger is that millions of people still think of Medicaid as a rescue system that begins helping the moment they are poor enough to need it. That is not how this works. Medicaid for long-term care is not only a poverty program, it is also a timing program. And timing in money is often more important than intention. A decent person can do all the wrong things for all the right reasons and still get financially crushed if he does them in the wrong 5-year window. That is the part people almost never understand until it is too late. They think the law is asking a moral question. Did you mean, well, were you generous? Were you helping family? Were you simply doing what seemed normal? The law is not asking any of those things. The law is asking an administrative question. Did you transfer assets within the look-back period in a way that triggers a penalty? That is all. And administrative questions do not care about family sentiment. A birthday gift does not become safe because you gave it with love. A card transfer does not become invisible because it stayed in the family. A tuition check does not become harmless because it helped a grandchild. A legal IRS gift does not become safe for Medicaid purposes because the IRS allowed it. That last point destroys more confidence than almost anything else. Once people see it clearly, they assume tax law and Medicaid law speak with the same voice. They do not. That is one of the oldest traps in retirement planning. Something can be perfectly acceptable in one part of the legal system and still produce a penalty in another. The federal annual gift tax exclusion is a fine example of this confusion. People hear that a certain amount can be gifted each year without federal gift tax consequences, and they quietly conclude the transfer must therefore be safe. But Medicaid is a different system with different purposes and different rules. That is why elder law planning is so treacherous for people who rely on common sense instead of state-specific Medicaid rules. The transfer question is not, was it allowed by the IRS? The transfer question is, does Medicaid treat it as a disqualifying, uncompensated transfer inside the look-back window? Fay site, Fay turn 55, file 0, Fay turn 280,405, search 4, Fay turn 280,405, search 6, Fay. That is where the trouble begins. Now, let us get the structure right for long-term care Medicaid. The look-back period is generally 60 months or 5 years. States review transfers during that window when determining whether an applicant improperly gave away or sold assets for less than fair market value before applying for institutional long-term care coverage. Federal Medicaid guidance and state plan materials reflect this 5-year standard. Fay site, Fay turn 280,405, search 4, Fay turn 280,405, search 6, Fay turn 280,405, search 0, Fay. Those are dry words, but real life is not dry. Real life is a widow helping a daughter with a car. Real life is a grandfather paying for a wedding. Real life is a husband putting a child's name on an account because it just makes things easier. Real life is a family passing money around in ways that feel normal, decent, and private. Then one fall, one stroke, one diagnosis, one hospital discharge planner asking a question no one prepared for. How are you going to pay for the nursing facility? That is when ordinary family behavior gets reinterpreted by a system that was never built to care about family sentiment. The look back is not there to ask whether you were good. It is there to ask whether assets left the estate in a way the state now wants to treat as disqualifying. This is why I tell people the 5-year rule is not really about the past. It is about delayed consequences. The punishment arrives long after the action, which is precisely why the action never felt dangerous when it was happening. That delayed consequence structure is what makes it so destructive. If the state punished you immediately, people would adapt. If every small family transfer came with an alarm bell, people would stop. But the system waits. It lets life proceed normally then. When the need for care arrives, it reconstructs the prior 5 years and asks whether your family behavior now creates a penalty period. This is not a fine in the ordinary sense. That would almost be simpler. It is a lockout, a period of ineligibility, a gap between when you need the money and when Medicaid agrees to start paying. That gap can be financially fatal. The person applies because he cannot privately afford the care. Then he discovers the application does not solve the problem because the transfers inside the 5-year window produced a penalty period that must somehow be funded first. This is where the cruelty becomes visible. You gave away the money. You cannot pay privately. The state will not pay yet. The nursing home still expects payment. That is the trap. Now, I want to say something carefully because a great many families get this point wrong. The home is often exempt for Medicaid eligibility purposes subject to state and federal conditions, including home equity limits and intent to return or occupancy rules, but exempt for eligibility does not mean exempt forever. Medicaid.gov explains that states are required to seek estate recovery for certain benefits paid on behalf of individuals age 55 or older, including nursing, facility services, and certain home and community-based services. That estate recovery comes after death, and the home is frequently the asset families feel most viscerally when recovery is pursued. Site Fay-Turn 280,405, Search 1 Fay-Turn 271,266, View 1 Fay. Do you see the difference? This is where ordinary language becomes dangerous. People hear the house is exempt, and they translate that sentence into the house is safe. Those are not the same sentence. Exempt can mean it is not counted the way other assets are counted during eligibility. Safe would mean it is protected from later recovery consequences. That second statement does not automatically follow from the first. This is one of the most brutal misunderstandings in all of elder planning. A home can be non-countable for qualification and still become the focal point of estate recovery after death. If you do not understand that distinction, you can spend years thinking you are protected simply because you are not being forced to sell before the application is approved. By the time the estate recovery question appears, the person who needed care may already be gone. Then the house is no longer an emotional home in the eyes of the state. It is part of an estate against which recovery can be pursued. This is where many families feel betrayed by their own assumptions. They were not wrong that the house had special treatment. They were wrong about what kind of special treatment it had and when that treatment ended. That distinction is everything. And now we arrive at the married couple problem, which is where the emotional damage becomes even deeper. A husband gets sick, the wife stays home, or the wife gets sick and the husband stays home. The healthy spouse assumes the law must surely protect the ones still trying to live in the community. And to be fair, Medicaid does contain spousal impoverishment protections. Medicaid S-2026 spousal impoverishment standards show that a certain amount of combined resources may be protected for the community spouse. CMS updated 2026 standards list a community spouse resource allowance, minimum of $32,532 and a maximum of $162,660, along with income allowances designed to prevent the spouse at home from being left entirely destitute. Site Fay-Turn 271,266, View 0 Fay-Turn 271,266, View 1 Fay. That is real protection. It is also less protective than many couples emotionally assume because people hear the maximum number and treat it like abundance. It is not abundance. It is a line drawn by a system trying to determine how little can remain protected while still claiming. It is not impoverishing the spouse at home. That is a very different standard from the one older couples themselves often have in mind. A paid-off home is one thing. Ongoing life is another. Property taxes keep coming, insurance keeps coming, roofs keep aging, cars keep failing. Food does not become cheaper because your spouse is in a facility. Medicine does not become cheaper because the state says you may retain a certain amount of resources. The math that looks survivable in an administrative handbook can feel very tight in real life. This is why people get into trouble when they assume their spouse protections means my spouse will be comfortable. Those are not the same thing. The law may prevent total devastation. It does not promise peace. And for many households, especially households whose wealth is concentrated in the house, plus moderate savings, the distinction between comfort and technical non-impoverishment is the entire story. Now let us address filial responsibility laws, because this is where fear can outrun fact if people are not careful. A great many videos speak as though children will automatically be sued in huge numbers for a parent's nursing home bill. That is too dramatic. But it is also not something I would dismiss casually. Legislative bodies and legal commentators continue to note that a number of states still have filial support statutes on the books. NCSL recently described such laws as existing in 27 states and pointed again to the 2012 Pennsylvania case that produced roughly a $93,000 judgment against an adult son. These laws are not uniformly enforced, and many remain dormant, but dormant is not the same as dead. Fay-site Fader 457,718 search 2, Fader 457,718 search 10 Fay. That is the adult way to think about this. Not every child will be sued. Not this never happens. The adult view is that these statutes remain another reason families should not drift into long-term crisis planning with no strategy, because once the money is gone and the nursing facility is owed, every dormant legal theory looks more alive. Creditors get creative when balances go unpaid. That is one of the oldest truths in law. Now, I want to explain why the timing problem is so vicious if you need care. Now, some planning tools shrink or become much harder to use. Well, if you plan early, your options are broader. That is why the people who lose the most are often not the most irresponsible. They are the ones who assumed planning could wait until there was a reason to plan. But Medicaid long-term care planning punishes late awareness. The best tools often need runway. That is the opposite of how many families think. They imagine planning begins when the hospital room enters the story. For this area of law, hospital room timing is often the beginning of desperation, not the beginning of optimal planning. The phrase many families eventually hear is Medicaid Asset Protection Trust. Now, I want to be careful again, because this is not a magic incantation and it is not appropriate for every family, every state, or every timeline. But conceptually, an irrevocable trust funded early enough can remove assets from countability and later estate recovery in ways ordinary wills cannot the 5-year. Look back is why timing matters so much. If the trust is funded too late, the transfer itself may still sit inside the look back. If it is funded early enough and structured properly under state law, the results can be very different. Fay-site Fader 55 file 0 Fay turn 457,718 search 1 Fay. That is why ordinary estate planning is not enough for this problem. A will is not a long-term care strategy. A general power of attorney is not a long-term care strategy. A simple revocable living trust is often not a long-term care strategy, because revocable control typically means the assets remain countable. This is where many otherwise competent middle-class families get blindsided. They did have documents. They did go to a lawyer once. They did sign the nice binder. They did think they had an estate plan. Then long-term care enters the picture and they discover the thing they bought was a death plan, not an asset protection plan for a nursing home scenario. Those are different tools for different threats. That distinction alone has probably cost American families billions over time. Now, in some states, there is another home-specific tool, often called an enhanced life estate deed or Lady Bird deed. Recognition is state-specific, and widely cited estate planning resources identify Florida, Michigan, Texas, Vermont, and West Virginia as the core states where the technique is commonly recognized. It is not a national solution, and whether it helps with Medicaid planning depends on state law and timing. Fay-site Fay turn 457,718 search 15 Fay turn 457,718 search 18 Fay turn 457,718 search 18 Fay. And the important point is not memorizing a phrase. The important point is understanding the category. The house may need its own planning tool. The rest of the assets may need a different tool. The timing may govern everything. And the attorney who is good at ordinary estate documents may not be the attorney who is strongest in Medicaid crisis or pre-crisis planning. That is why credentials matter more here than families often realize. A certified elder law specialist or a genuinely Medicaid-focused elder law attorney is not the same thing as a general practitioner who can draft a will. This area is too technical, too state-specific, and too timing-dependent for broad familiarity to be good enough. That is one reason I find this subject so morally serious. The families most likely to need the planning are also the families most likely to assume that one general legal visit years ago solved the issue. Then a child is suddenly sitting in a hospital conference room hearing phrases like private pay, spend down, Medicaid pending, and estate recovery for the first time while the meter is already running. That is the wrong moment to learn the vocabulary. The right moment was years earlier. That is what the 5-year rule really means in practice. It means that the most important day in the process may not be the day you enter the facility. It may be the day 5 years before that, or the day you should have moved the assets but did not, or the day you made a gift that felt normal but later counted against you, or the day you said, "We'll deal with this when we need to." That sentence is one of the costliest in elder planning. Now let me say something equally important. Not every family will need a complex trust structure. Not every family can be fully protected. Not every state works the same way. Not every home can or should be transferred. Not every transfer is wise. And not every nursing home story ends with a forced sale or the maximum recovery outcome. This is not a place for blanket promises. The honest version is more demanding. State law matters. Asset mix matters. Marital status matters. Health status matters. Whether care is already needed matters. Whether the applicant is in a nursing facility or pursuing home and community-based services matters. Whether a spouse or disabled child remains in the home matters. Everything depends on facts. That is why the emotional temptation to seek one perfect national rule is so dangerous. There is no single national family solution. There is only a family-specific, state-specific, time-sensitive planning problem. Once you accept that, the response becomes clearer. First, stop assuming the house is safe just because someone once told you Medicaid will not make you sell it before qualification. That is only one part of the story. Second, review the last 5 years of transfers. If you or a loved one may need care in the near future, do not guess. Actually review them. Third, find a real elder law specialist, not just a lawyer who handled the simple will 10 years ago. Fourth, ask direct questions. How does my state handle the look back? How does my state handle estate recovery? What happens to the house? What tools exist for pre-crisis planning? What is still available if the need for care is already close? Fifth, do not confuse delay with prudence in this area. Delay is often just lost runway dressed up as caution. That is the deepest lesson in the whole subject. The people who get hurt are often not reckless. They are late, and late is enough. Late turns legal tools into missed opportunities. Late turns gifts into penalties. Late turns exempt homes into estate targets. Late turns family confidence into family shock. That is why I think this issue deserves much more attention than it gets. People will spend months arguing over which ETF to buy and never spend one afternoon learning the rules that may decide whether the house survives a long-term care event. That is backwards. You can recover from many investment mistakes. A long-term care planning mistake made too late can rewrite a family's balance sheet for a generation. That is not a dramatic slogan. That is just arithmetic with law attached to it. And whenever arithmetic and law start working together against a family, emotion is a very poor defense. Preparation is the only good one. So if you want the simplest honest summary, it is this. The 5-year rule is not simply a trap for cheaters or the ultra-rich. It is a timing rule that can punish ordinary families for ordinary transfers if the need for care arrives too soon afterward. The house is not always as safe as people think. Estate recovery is real. Spousal protections are real but not infinite. Some states still carry dormant child support liability laws for parents' care, and the best tools often work best before anyone feels sick enough to need them. That is the whole lesson. Not fear, not panic, not surrender. Just a refusal to let the first time you seriously think about long-term care asset protection be the same week the nursing home asks for its first private pay check. That is too late for comfort, and comfort in this part of life is bought with earlier clarity. Nothing else works as well.